attorney to tell us how this meeting will be conducted. Ms. Christy Barté.
Good evening. It's been a while since we've had one of these, I think 2015, but so that everyone is aware of the procedure, Mr. Fields for the Codes Department will make his presentation. Ms. Smith's attorney will have his opportunity to then make his presentation to the board. We will open for questions from the board to Mr. Fields and to Ms. Smith's attorney. Someone will make a motion to uphold the decision of the Board of Construction Appeals. Voting yes on that motion will uphold their decision. Voting no will terminate that decision. Any questions?
Okay. We can go back over that. We can go back over that.
We can absolutely go back over.
I remember in 2015, we had lots of questions when we got in the middle.
Lots of questions.
We ask no questions until they're both done.
No,
That's correct.
no questions. Mr. Fields.
Okay, thank you, Madam Mayor. Boy, I wasn't nervous till just now, and I've gotten kind of nervous. My name is Mark Fields. I'm the code administrator for the city of Springfield. I work in community development, and David Brewer is my supervisor. At the first of the year, January, I found a building damaged. The roof and ceiling had collapsed over on Batts Blvd, and I issued a slum clearance to the owner, Miss Marilyn Gay Smith. And the slum clearance is a state law that this body adopted in 2004. And I gotta catch up this is the building, and this is the slum clearance. And basically what the slum clearance does, it allows a public official to make a determination if the building can be repaired or not. There's a whole thing on the slum clearance law. And the reasonable means if it costs 50% of the cost of the whole premises. So that's kind of what we're trying to do, is decide whether the repair costs are within 50% of the value of the whole thing. And then it would be deemed not reasonable to repair if it was more than that. And so there's like 6 requirements for the slum clearance. There's a complaint hearing, and it's an informal meeting with me and the owner. And Marilyn and I had this meeting in this room back in January, and I'd asked her to find out what's wrong with her building and get a contractor to tell her how much it was going to cost. And I would do the same. And then at this meeting we would kind of decide if it was reasonable or not. And so then there's a fact of finding. That's just a list of my inspections of all the deficiencies, the violations. We write that all down. Then there's the estimate of the cost repair. And I conduct this estimate a couple ways. I'll do it price per square foot, and then I'll do an itemized list for whatever is damaged. I'll try to figure out how much it would cost to have that particular item. Sometimes I'll get a separate contractor, an independent contractor, to do an evaluation, give me an estimate. And I did that on this particular job. Brent House with Drake's Creek gave us an independent estimate to see. And then I average those up and try and just get an idea, and I average those estimates together, and that gives us a cost estimate of what it's going to cost. And then there's an assessment of the approved value. We get that from the Tennessee tax assessor. He gives us an idea of what the property is worth, the whole improvement and so we use that as just a basis. And then our cost estimate, the fact of finding, those are the things that really we go over and determine if it can be repaired or not, if is it reasonable. Then an order to the owners of unfit structures is issued, and within that, it can be, if it found that it can be repaired reasonably, we'll get it repaired reasonably. If it's decided that it cannot be repaired, then it has to be removed, and we'll set a time frame for which that to happen. And then there's the appeal process. That's what we're in here today. So I make a decision, and not necessarily everybody goes along with my decision, and so then it can go to the Construction Board of Appeals. There's 9 men on that board, and we meet on a call basis. And so we did that, and now the next step would be go to the mayor and aldermen. And then there's another step where they can file a complaint at Chancery Court, and that would be another avenue. So we're gonna go through these different processes so she can be heard on the thing. So I make my determination based on the fact finding, the estimate, and the value of the premises. And there's other information too, like an engineer's report that she brought, that would figure in. There's historical records on certain buildings. So there's other issues too that we take into account, but mainly it is the fact of finding the value of the building versus what the estimate, the cost estimate. That's what determines whether or not it's reasonable to repair. And I'll just say that Springfield started dealing aggressively with blight and unfit structures in 2010. And there was many reasons that the city needed to have a strategy to take on this. And the first 5 years was very difficult. We did this quite a bit. It was difficult. And then, but this board appropriated funds for the demolition, and then the city actually removed like 30%. I would identify these slump clearances, and the city actually used Public Works, and we removed about 30%. The owners did 70, and we did about 30% of them, and it really was successful. And then property owners realized that the city was very serious about cleaning up, and today the city, we've only had to remove one last year. There was the Carter Lumber Company that caught a fire, and we had to do a demolition on that. The property values have increased as a result, and the owners are going ahead and doing demolitions and building back themselves. And I would like to recognize Jim Moore and Harvey Combs, Pedro Reyes, Denver Krantz. They are adding a lot of value back to Springfield. They're taking these old dilapidated structures down, building back, and it's helping really clean up Springfield. And there's still a lot to do, but a lot of progress has been made. So as I said earlier, some clearance hearing was held right here in January, and Miss Marilyn asked me not to postpone my decision. So she brought with her what I'd asked, an engineer report and a contractor with an estimate. And she brought it that day, and we started looking at it, and the engineer report basically said it was not advisable to repair the building, and it wasn't really reasonable, and she wanted a clarification, which I would understand. And then the contractor said, I can't repair it for this cost. We'll have to get another estimate. And so, because it was over the 50%. And during this, she kind of agreed that she wanted to tear down the building to build it back. Well, that was gonna be a problem with our zoning ordinance, because it doesn't meet our zoning regulations, and it's too close to the road. And so if we removed the building or tore it down, we couldn't build it right back. So, but I wanted to get a clarification from our director to make sure that was in fact correct. So I needed she was gonna get a revised engineer report, and I was gonna get clarification from the planning director on the zoning issue. Those were the two main things. And she was gonna go ahead and get another estimate for the revised section. So, we scheduled that for February, but then we rescheduled, and for next 6 months, we scheduled and rescheduled and scheduled and rescheduled. We couldn't come up with a time. Until July 6th or 9th, I said, hey, we gotta decide and this will be the last time we change this meeting. And we agreed, and so there was a date set for July the 28th. And about a week later, a few days later, she tried to cancel, and I had the meeting with Al. And I made the determination because she had already given me the revised engineer report, and I had David had issued a letter on the non-conforming building that we would not be allowed to rebuild the building. So with that information and the rest of my cost estimates and everything, I had enough information to make a decision that it was not reasonable to fix the building and it needed to be removed. And I issued that order on that date. And with that, I gave her some information on how to appeal and that, and she did appeal to the mayor and aldermen, to the Construction Board of Appeals. And so at the October the 5th is when we had the construction board meeting, and Mrs. Smith did not attend the appeal. She called the day before and said she had another conflict and was going to try to reschedule, but that was not reasonable to reschedule in one day. The 9 men taking time out of their busy life to serve on the board, and with one day, I told her no, that it was not reasonable. So we went ahead and had our construction board hearing, and she was not present. And I did a presentation similar to this, and the board found that, well, I showed a similar presentation, and which included Marilyn's revised structural engineer report, and it said that it needed to have new footings, new walls, new floor, new roof, and basically it's a whole new building. And so, and I showed them the letter from the planning director that said that it would have to be built with the bulk regulations. It couldn't be built in the same location. And with the slideshow pictures, the construction board unanimously upheld my decision to remove the structure. And I'm sorry, I'm getting carried away. So I have some pictures here. This is This is the inside of the block building. Now on Batts Boulevard, there's 2 structures. There's an old house that's boarded up, that's vacant. That's not what we're talking about right now. That's on the same property, that's hers, but we're not doing a slump clearance on that. There's a little building that was used as a church, and it's a little block building. And that's what we're talking about today, just the block building. And the roof had collapsed, and this is the inside of the church. This is the roof on top. It's a rubber roof, and it had just collapsed down inside, and it's leaking, and the walls are blocked, and it's pulled in, and it's all deformed, the walls, and they're damaged, the exterior walls. You can see a big bow in them. They'll have to be replaced. These are exterior wall, parapet walls damaged, and the opinion of the engineer was that it was all that had to be replaced. It couldn't repair it, had to be replaced. The walls, the foundations, the floor, the roof, and that's kind of bad there. That's where it was posted on the building. Has some stuff outside, and so the repair cost that we came up with was about $120,000, to repair the building. And my cost estimate from the engineer is like $180, and then if you price it out per square foot, it's about $153 a square foot to do that. 153. We had an average cost of everything is 120, 478, and that's 118 times versus what the properties actually were. And so that's where that came from there. And then in the zoning ordinance, this is where it says that it has to be constructed with the bulk regulations. So that's if the building is damaged more than 50%, it has to be removed and build it back according to the zoning regulations. And we wouldn't issue a building permit. Even if the slum clearance, so that's kind of two different things. The slum clearance is based on the value of the thing. And then the zoning ordinance is just another thing. But it's part of the fact of the finding. So, the 2021 improvement value is $102,000. That's from Chris Strauber's information. And then those repairs cannot exceed $51,000. And my cost estimate is everything about 120-something thousand, which is way over 50%. We're not trying to split hairs. If it was reasonable, we would allow her to fix the building, but it's way gone. And that's what the construction board said, it's way gone. It was way more than 50% damaged. It cost more than 50% to have it repaired. And those decisions. I would like to go, can you pull up the engineer report, please? So, Miss Marilyn did a nice job and she did what I asked her to do, get some information on what's wrong with the building, and then get me a cost estimate, and we could negotiate and see what that was. And she did a nice job. She hired a really nice guy. But his engineer report, and I've got a highlight, and it's really if you could blow that up maybe, but it basically says it would still, this is the revised plan from the engineer. It says it would still be necessary to replace the footings, the piers, the floor, the exterior walls, the roof. It's a whole new building we gotta do. And so he goes in several places that he says it's not advisable or, in his opinion, reasonable to repair the building. It's very difficult. And so with that information it helped me make my decision too on that. But I made all that decisions without her being present, but she'd already given me the information. She gave me that information. With that, I'll just say, does anybody have any questions about the slum clearance process? Or?
We'll take questions at the end.
Okay.
Okay? It's Ms. Smith's turn now. Hello.
Good evening, Mayor, members of the board. I appreciate your time. My name is Nick Schulenberg. I'm with the law firm of Freeman and Fuson out of Nashville. I'm frequently here in Robertson County, so good to be back. And as Mr. Fields had indicated, this is kind of a situation where, for one reason or another, our client really hasn't had her full opportunity to really be heard and be put on the proof that she wants to kind of dispute these actions taken. As every property owner probably or homeowner can relate to, there's nothing more unique or personal than property to an individual. There's nothing that kind of gets, in my experience in dealing with a lot of boundary disputes cases and stuff, nothing gets people's emotions kind of more involved than their property. It's just holds a lot of sentimental value, especially when there's any sort of action to be taking that away. You really would like to have that opportunity to be heard and sort of contest those actions in a meaningful way. Now, whether one reason or another, I know there were a number of scheduling issues, and my client has, provided documentation showing that there were legitimate issues, just had a lot of stuff going on in her personal life that's prevented her from being able to be there at those other opportunities. But I don't think that in any way diminishes her desire to be heard and to speak to this very personal piece of property to her. Now, I understand that, Mr. Fields, as he probably has done a million times, he's finding it, as he indicated, based on those findings of fact, the repair costs, the value that the property is estimated at. And it's really that those are kind of the issues that we would raise, is that we would like to dispute some of those findings of fact, especially particularly the repair estimates that are provided and that Mr. Fields has noted. It kind of forms the basis for his decision-making. I know there were a number of of the repairs that were listed out and itemized. There were ballpark figures, attested to what those repairs would cost. And my client just wants an opportunity to properly get a licensed contractor to provide her own rebuttal proof of what these repairs would cost. I know there was an initial contractor, that was retained. We noted the TCA, I believe, provision that was pointed out that required a licensed contractor, so she needed to get a new contractor to provide these estimates, one that was licensed and could perform the work, was not able to do that, and then subsequently had some issues with being able to be here the second time around. Really, we're asking the board here today to simply remand this back to the construction board, so we do have an opportunity to speak to the individuals that are I guess, called in on these sort of issues more often. Not to admit that there's any dispute that the board is fully capable of making these decisions, but like I said, we really would like an opportunity to be heard by the, I guess, the panel that was initially have been heard prior to us even arriving here today. And for those scheduling issues, we weren't able to do so. It's that kind of that 50% mark that we'd like to be able to put on proof to show that there is, when we have our own experts, just as of any other, situation, one side has their experts, we'd like an opportunity to get our experts there to put on some rebuttal proof there. And also, I'd point out the fact that, of course, we do have other avenues, of course, if the board does decide to uphold this decision. We could file in Chancery Court, but I'd argue, this building has been in place, has been a part of Robertson County since 1940. It's been here for 80 years. I don't think 80 and a half or 81, a little bit of a further delay if that's what's required to go back to the construction panel and have this be done on a full hearing on its merits. I don't think that would hinder the citizens of Springfield at all. And I think it would just goes to show that the board has its citizens' interests at heart, and that if this would ever happen to another individual, I think that certainly any property owner would like an opportunity to be able to gather the required proof to put on their case and argue that this piece of property that's meant so much to them up to this point should at least take careful consideration before it being removed and taken away. If you just give me 1 second. That'd be all.
Thank you. Okay, we're ready now to take questions.
Ready?
Yes, sir?
How long has she owned this property?
15 years, 15 or 16, she owned it. It was Mr. Sanford. Remember Mr. Sanford?
Yes.
He donated that to them when he passed.
Okay. And did I understand you to say when you were talking that she did not object to the building having to come down?
That's correct. And in our,
But there's some issue about what can go back?
yeah, the problem is you can't build the building back in its current location. That would violate the zoning ordinance.
Okay.
So the building is damaged more than 50%. Our zoning ordinance says that cannot be built back like it is. It has to meet our bulk regulations. And that's a whole nother problem. So, even if the construction board said she could rebuild it because the value is okay, it was within 50%, say, well, our zoning says you can't build it back because the building is damaged more than 50%.
Okay.
There's no way.
And then this whole process you stated started around the first of this year?
The building collapsed in January, well, actually, I found it collapsed.
Found it
In
at
January,
first
the
of this year.
5th of January.
Okay. So then to your attorney, you made the statement that she wanted to be heard and with the construction board to come back on this. How many times has this meeting been scheduled? Do we
Mr.
know,
Fields?
Mr. Fields?
18?
It's been scheduled 18 different times for the construction board?
No, just once for the construction board.
Oh, no, just one time with the construction board, she appealed and set the date, and so that was, she called the day before the meeting, that was not rescheduled.
Okay, so the construction board's only been scheduled.
Determination.
Okay,
So from January to July, every month, a couple times a month, we were gonna schedule, but something happened. And so we were gonna do a phone.
with her scheduling or your scheduling, or both?
Hers and mine. I mean, there was legitimate reason. There was bad weather, and then she was detained out of the country for a month, and then she had a toothache, and she had, there was, I mean, I don't, I'm not saying that those
I understand.
postponements and those rescheduling.
But as far as the construction board itself, there was only one meeting scheduled, and she had to cancel that the day before, or cancel her appearance the day before.
Okay.
And then if we were to not oppose this, does it automatically go back to the construction board, or is it done? Is it, what takes place? Can we order it back to the construction board?
I believe you can order it back to the construction board. If you don't uphold, it would go back to the construction board for determination.
Okay. And then with what you showed a moment ago was a report from the engineer that she hired that stated all this stuff still,
It's not really advisable or reasonable to repair. But what they're saying is they have a cost estimate, they want to have a cost estimate that says it is reasonable within, they could repair the building.
but yet the engineer they hired said it is not.
Mr. Fields, can you come to the mic so we are recording this?
But
You
the
have a
en-
question?
but-
I'm sorry.
Just, just a moment. Our city attorney.
Do we have some documentation that shows that Ms. Smith is the authorized representative for the Church of the Well?
Yeah, it's documented at the county.
I don't have anything on me right now. You have to investigate that, of course, and
It's
provide the
documented,
documentation.
it's documented at the county.
And everything's been addressed, to the Church of the Well.
Marilyn Gay Smith,
Great.
business as the Well Restoration Church.
Okay.
But I'd like to,
Hold on just a minute. Mr. Fields is still at the mic. Do you have another question for Mr. Fields while you have the floor?
I had him a question before we started this, so what is?
go ahead.
But go back to while he's at the mic.
exactly what we asked. I mean, we were talking about that her own engineer stated that they did not, the engineer that she hired
Right.
stated that they did not think it could be.
She provided me with a revised report from her engineer that really said that the building was not reasonable to repair or advisable to repair, that the building needed new footings, would have to construct new footings, new walls, new floor, and a new roof.
And this is from the engineer she hired.
Yes.
Okay, so
So we gotta build a
just for
brand
a
new
point of
building.
information,
We can put that back up on the screen if you'd like.
just a point of information, if we did not uphold what has taken place so far, what happens to it? Does it go back to the construction board? Is it a dead issue? What takes place? Do we know?
You,
If we did not agree with what the construction board found?
My understanding is, if you don't mind, that there has to be some resolution. So to just not uphold it, we would have to say that the board would have to say that it goes back to the construction board for a further determination of whether or not it does reach the 50% threshold, because the zoning ordinance is still in effect that says if it's over the 50%, then you can't build it back, or you have to take it down. Now, there's still a zoning issue with the setbacks that Mr. Fields was alluding to, that you can't build the building that close to the road. So even if she were to build something back, it can't be that close to the road. So
So if we uphold it, then they're at their liberty to take their next step.
Yes.
If we do not uphold it, we have to give instruction as to what to do.
that's correct.
I'm just asking for
Yeah.
information.
Sure, it's a good question.
There would have to be some, to not uphold it for some additional resolution, because the building, we still have a building with a roof collapsed, that still has to have some resolution to it. We can't just, let it be.
okay,
I have no more questions right now.
all right, we'll move on to the next questions.
May I just address part of what was?
Yes, sir.
A question that was answered sort of by Mr. Fields, I just wanted to jump in there. And I do, correct me if I'm wrong, but in the report that was provided by her expert, while it does mention the, difficulties and the things that would need to be repaired to the building, they did not outright state that complete demolition of the building would be required. There was an avenue they could pursue. Granted, obviously, some repairs need to be made, but they did not unequivocally state that we are of the opinion that destruction is the only, method to fix this issue. And that's kind of what we would be pointing to, and the fact that we do contest that 50% valuation that's so key for both of the issues presented, and just like an opportunity to properly put on proof. I would point out the fact that, my client has been very proactive, and compliant with, Mr. Fields and trying to get that expert proof prior to ever retaining counsel. It wasn't until things went, haywire a little bit that she has retained counsel. We are on board. So of course, if we have a new opportunity for a new meeting, we'll be assisting in making sure that's properly calendared. The expert proof is properly, obtained prior to, meeting again, or with it, whether it be, with the construction board or whoever it be. Chancery Court.
Mr. Martin,
Yes, sir, I have a question for you. One of the crux of your argument for remanding it back to the construction board is have an opportunity to put on proof that it's not reached the threshold of 50%. Do you have that proof tonight?
So we do not have that proof,
Okay.
as I stated. Now,
Well, let me follow up with that and say, with the Construction Board of Adjustments and Appeals hearing that was scheduled for October, that Ms. Smith received proper notice of, and I don't think the proper notice of that meeting is in dispute, is it?
it is not.
Okay, so if the proper notice of that meeting's not in dispute, and knowing that there was a presentation required or an opportunity to be heard at that meeting, then a month later, this was advertised as an appeal hearing, my question would be, why would this board believe that there would be proof put on at another construction board hearing, or would there be another excuse for a delay?
Eh.
Can I make a statement?
you need to come to the mic. Since this is a recorded meeting, we need to all be at the mic. Yes, ma'am.
First of all, thank you for letting me speak. Secondly, I didn't get proper notice about the construction appeals. I normally get a certified letter in the mail. I got an email from Mr. Fields. So I was waiting for a certified letter in the mail, because every time they send me something certified. So I did not even realize that there was something put in the paper, there were gonna be a group of 12 people, but besides not realizing that, I told Mr. Fields that my car was totaled, I was in a total wreck, August the 8th. My son was shot 5 times right after that. And I had to take care of him when he came home in September the 1st. I explained these things to Mr. Fields. It was not a day before the meeting. I thought that I would have my vehicle back because I had to buy it back from the insurance and wait for them to do all the inspections, and with COVID going on, they took a long period of time. So everything that I've tried to do, I've tried to get everything that he wanted me to get. I told him that if I had to drive my car, and I told my mechanic, if you could just get it running, whether I have an alignment or not, get the proper tie rod in put on, I'll drive it like that. I have all my documentation with me that he got it done a day after. I paid for it. I have my documentation that I had to get an alignment. I went to 4 alignment places. This is after. So, no, I didn't get notice, proper notice about the construction hearing. Now, as far as getting to the hearings before, I was in Nigeria. I had to cancel because I had lost my passport. So I let him know from Nigeria. Right after I left Nigeria, I let him know that my son was graduating basic training. He's 19, he's my youngest. I let him know and ignored my calls, didn't answer my emails at all. I had to make a choice between expecting that he has been gracious in the past, that he would go ahead and continue the meeting. So I had to be at my son, and I have that with me too. The day of the meeting was the 29th. This is my son graduating on the 30th. This is before I had a car wreck and my car was totaled. This was before my son got shot. So I don't know about anybody else, but that's not normal circumstances. So I was not able to do a lot of this stuff.
Okay.
So I'm not here to take my lawyer's job, but there's the construction engineer told me that this can be done. I did not give him a revised report to show anything different, except that he did not understand it. So the gentleman was nice enough to re-explain it and send a revised report, but he didn't say that it's not good to be, like my attorney said, that it's not good to be repaired, or like a normal person, take time and figure out what was going on. Mr. Fields also didn't state that somebody was working on the building when he went into the building and saw the roof was down. I knew the roof was down, but I had somebody taking care of it. This gentleman that let him in to see it caused this to speed up the process, and Mr. Fields told me, cease all work. So that was months of work that I could have done on other stuff. The estimate you guys have, it has windows. I don't need windows. There's no windows broken. There's a lot of stuff on that estimate that has nothing to do with the structure or the roof.
Okay. Anyone have questions while they're still at the mic? Yes, sir.
When was the last time this building was actually occupied?
2016, when they took my tax exempt.
Okay.
Okay, now,
Pay back taxes
the
of
construction
like
board,
8,000 or 9,000.
the construction board made 9 members, you say?
Yes, sir.
Now, what's their occupation? Are they people in the construction field?
They're all contractors or architects or engineers.
And all 9 of them voted unanimously that this building needs to come down?
Yes, sir.
Okay.
Next question from the board? Yes, sir.
Oh, boy.
And I'll move on to this side of the room. Would you like Mr. Fields to come back up, or?
And no, I'm gonna handle this. Have you been dealing with that piece of property as a church restoration
It was
center?
It was a church and a halfway house, and I've been
And-
dealing with the city since 2008, fighting me against having a nonprofit business as a black businesswoman in Springfield for ages.
A point of order, point of order. I am black to the bone and proud of it. But I have been on this board for 25 years. I'm not trying to prejudice this meeting, but we've been going through some changes with your facility ever since you organized it. I mean, I wish the rest of the board wouldn't pull up the history of what actually been going on out there. You follow me?
What changes, sir?
Why did you lose your tax exemption?
Because you guys decided that because I wasn't using the house and the church, that it constituted not using the property, and I was using the church.
There was no negligence on your part
No, it wasn't, sir.
in operating this?
No, sir, it wasn't.
Okay, we need to get back to our discussion.
Okay, well,
To our
I'm
point.
getting back to the discussion. This is all relevant to it. Okay, so it's been sitting out there unused for how long?
Since 2016, when I was handicapped into not being able to afford to pay all the taxes, to catch up the taxes, and still operate the property, and going back and forth with hearings with the city of Springfield. One of the things, and if you want me to go through, one of the things in 2010, when one of your persons here that worked for the city opened up their halfway house, the same day he opened his halfway house, they sent codes, someone sent codes to our property and said, well, it's not up to standard, shut her down. The very same day he opened, Mr. Robert Gardner, and they shut it down. They made me go through the city
Our-
to be
okay.
able to open it back up.
Mayor, please.
Our attorney will
Well, let me-
speak. Hold on.
Oh, no.
Hold on.
I have not been heard fairly because there's something that a lot of you all wasn't on board when all this started.
But with respect, Alderman Hubbard, that is,
Not part
the
of this.
history is not the issue of why we're here today. Those would be new facts and not appropriate
I
with the
know
board
what
at
it
this
is.
time.
The issue is, it hadn't been used. It's been put in negligence for a long time. I'm out there every day. I personally, understand me, I personally, I detest the position of that building, the condition. You see, so it hadn't really been used. I haven't seen any effort to really make it a suitable place to even use.
Okay, we're back to our subject. I'm gonna move on down to Mr. Gregg.
Well, he can go, Mr. Gregg, but I just want to clear out a statement. We did not discriminate against you
I didn't say you did.
because of Mr. Gardner's situation. Totally different. So I'm gonna be quiet on that, okay?
Thank you, Mr. Hubbard.
The date that happened, I didn't say you did.
Mr. Gregg, do you have questions?
No.
Ms. Arnold?
The only question I have about building back is, if she were to build back, and obviously the setbacks are the issue, could she not apply for a variance?
Come to the mic if you're answering the question, please.
The property got two different zoning classifications on it, but it's one parcel now. The portion of the property that is zone CS is less than the bulk regulation of minimum 10,000 square feet. The process would have to have, property would have to be subdivided through a subdivision plat process, and then rezoned, and then a plan submitted. There'd have to be appropriate parking, there'd have to be appropriate storm drainage, there'd have to be appropriate landscaping, in addition to the rebuilt building. So you have to meet bulk regulations, and you have to meet all current regulations when you repair, or take a building down and replace it.
And we have several developers that do that
Yes, ma'am.
regularly.
Yes, ma'am.
Okay,
No more questions.
thank you. Ms. Green?
If the property or if the building were to be rebuilt, what would you use it for?
Well, I wanted to repair it rather than rebuild it when they said that we could not, have it the same. It would have to be moved back, and if you move it back, there's nowhere to move it back. So you would just have, according to them, it would have to be torn down anyway. But I personally suggest that if the city is so interested in making sure it's a better place and a nicer place, if they had or would have supported the vision that I had, we would have somewhere for people that need help. I did this since 2003. There are people that came through my program that are on jobs right now still at these factories working for years. So that's how long we've been doing that. 2016, my husband died, my children's father. And I could not, with the tax exempt being taken away, whether we were using the church or not, I could not afford to travel back and forth. I was traveling from Alabama. I'm from Alabama. I was traveling to at least have church services. I could not afford that.
Okay. I have one other question, which would be, have you already gotten in contact with an engineer that you anticipate to use to show these, put on the proof that you're suggesting you have?
I think that really a contractor would be part of our main, but now we do have the previously provided engineering reports.
Correct.
I think that we need a contractor, a licensed one. We had an initial contractor
And
with
I
licensing
did.
issue.
Do you have that person already?
I had a contractor a couple months ago. He came down and looked at it with one of his partners, and he said he would have my report for tonight, and he doesn't have it. I've called him. I can show you text messages in my phone. I asked him to have it at least by the 10th, but I didn't get any answer. It's really difficult to look at a report like that and a contractor wanting to come behind it and thinking they're gonna have their license. I've actually had people say, no, I don't want nobody to take my license if I try to help fix this
Okay.
situation.
No further
Ms. Green,
questions?
you're finished? Yes, sir.
To me, the thing that we're here is to decide, I mean, what's got to be done to this building. The shape that it's in is the shape that it's in. And what's led up to that is not really that. My question about something that you said a moment ago, that you were not properly notified about the construction board meeting.
Yeah, I did.
That you, what is the degree of notification for that? She stated that she had received certified letters for everything
Mr.
except
Fields, come to
this.
the mic, please.
Mr. Fields can address what he did, how he notifies her for the meetings and the emails.
So for the construction board hearing, I sent a certified letter to her and an email with the same stuff and then an attachment of the meeting and everything. And I have an email that said that she received the email and she received the letter.
Was that a signed certified receipt?
I said I
No,
received
she told me that in an email.
No, what I'm asking is, she said that she had been notified of other things by certified letter. She's stating that for the construction board meeting, she did not receive a certified letter. You stated that she did. Do we have proof of that? Or is it required that she be notified by certified?
I think what.
I don't have the certificate back that she signed for that. I have an email saying she received a letter and the email.
I said to you
Both.
by email when I received your email. And then I was,
Okay.
and
Thank
I'm asking, was a certified letter sent to her
The
for
answer
the
is
construction
yes.
board? Do we have proof of that?
Yes.
Okay.
And what is our proof?
And you also have an email stating that she received it.
Whatever we do, I don't know that our outcome's going to be any different, but I want to make sure that the city as a whole has done what our responsibility is to do. She's stating she did not get a certified letter. We're stating she did.
Well, she actually did state she got a certified letter. She stated in an email to Mr. Fields, Mr. Fields can produce that email for you. She sent him an email, according to Mr. Fields, that she received a letter and received the email, which consisted of the same substance that the
I
letter.
thought I understood her to say she did not receive a certified letter for the construction board meeting. Did she say she didn't?
Okay.
Let me ask her one question.
Yes, sir. You asked a question while
Ma'am,
Mr.
if this building is in that kind of disarray, why did you not keep it up during all this time? Why'd you just wait till it all hit for Mr. Fields to have to do that?
It wasn't any kind of disarray like that. I could go into the building, come out of the building, never seen any problem except we had a slight roof leak. And underneath it says one of the beams was scorched. The beam was scorched, but it was never burnt. The beam was scorched when we first got the building. It was no damage to it. We got structure reports from Clover Engineering that it was just a scorch. But it's like somebody went underneath there and like pushed the beam in or whatever the case is. I don't know if it was the person that was working on it, that I had paid some money to do some work. He was doing some cementing and things, and he was gonna make something to make the rain come off of it a different way. I don't know if somebody did it on purpose, but all of a sudden, the bottom beam, from my understanding, caused the roof to collapse and the floor to fall in, all out of nowhere, that happened.
Okay.
Okay, I have a question for our city attorney, Ms. Barty. Ms. Barty, if we overturn this, all of our other construction board appeals could be in jeopardy, correct?
I would say the statute of limitation has run on those, but it would set a precedent.
Okay, so that would make our whole system in question for appeals in our slum.
Based on what Mr. Fields has said today, he has followed a procedure. The procedure was questioned, and how he conducted the procedure was questioned in our last slum clearance.
Right.
Our court approved his procedure, approved the procedure that he followed, which is consistent with what he has described today. So, I feel like that we have carried the burden.
Mr. Harris?
Unless there are other questions, I mean, Mr. Fields has done what he's set out to be done. Our city attorney feels comfortable with that. There are other avenues if they don't stand in agreement. This has been going on for some time. I would make the motion that this board uphold the appeals board decision.
Okay, there's a motion on the floor. Do we have a second?
I will second that motion.
Okay.
If I may briefly state, I feel for you, all the things that you stated have happened in your life. My heart goes out to you. But I have to uphold the procedures that we have in place, and with those being followed properly, I have to uphold the board's decision.
Okay, we have a motion and we have a second discussion on the floor.
I need
Yes,
to
sir.
comment.
Yes, sir.
I too, ma'am, I sympathize with all of the stuff you've gone through, okay? And I also appreciate your zeal for having compassion for needy people. So I want you to know that up front.
Any other discussion before we vote? Any other questions for any more?
I'm ready to vote.
Okay, we're ready for a vote. We can do that, Ms. Barty. Okay.
And Ms. Barty, would you explain the vote again, how yes or no, what a yes means or a no means?
A vote to uphold the decision of the Construction Board of Appeals states that the property will be torn down. A vote no states, a vote no is that the property, it could potentially be returned to the Construction Board of Appeals, whatever you all decide to do tonight.
Okay.
Thank you.
Everyone understand what they're voting?
And the motion on the floor in the second is to uphold the decision of the appeals board.
Correct. Any other discussion? Questions about how how the vote would play out? Make sure you understand it correctly. Okay, we're ready for a vote.
Explained it quite good.
Ready for a vote?
Green,
Yes.
Harris,
Yes.
Hubbard,
Yes.
Gregg,
Yes.
Arnold,
Yes.
Schneider,
Yes.
Trotter.
Yes.
Motion passes 7-0.
Meeting's adjourned.
Chief. Chief.